So far, we've looked at the legal ingredients of a contract. They are offer, acceptance, consideration, and intent to contract. Then we took a closer look at the terms of a contract. Courts will endeavor to enforce contracts. It's the undeniable norm. However, there are some exceptions where courts will choose not to enforce contracts, and that's the topic we're going to be exploring in this section. It's important to understand that the chances of being able to rely on any of the doctrines that we're about to discuss are remote, but they are possible. So here's what you need to know. You should understand why enforcement of contracts is the norm, understand the exceptional circumstances in which contracts are not enforced, understand which contracts must be in writing and why. And then I want you to know the doctrines of legal capacity, duress, undue influence, unconscionability, misrepresentations, mistake, illegality, and writing. And you might ask, well, what is a doctrine? It's basically a principle of law that's established through past decisions. So it's a principle of law, or a legal rule, I sometimes call them. I'm going to refer to these often, and you should be familiar with them. Then there are the key terms that you need to know, and there are 3 cases that we're going to look at from this chapter. So once negotiations reach an agreement that appears to contain the consensus of the parties on the essential elements of a bargain, then a contract is said to have formed. As I've stated, the law is normally concerned with enforcing contracts, and it's really quite difficult to back out once you've entered into a contract. Why do you think that's the case? Take a moment to think about it. It's difficult to back out of a contract because if it were easy, the value of contracts would be lost. The law focuses on enforcing the agreement in order to preserve the integrity, reliability, and predictability of contractual relationships. We'd lose all of the advantages that we have by having contracts in place if they were just easy enough for someone to back out of. So, even though the court will endeavor to enforce a contract, it's sometimes necessary for the court to intervene and allow a party to cancel or to avoid a contract. And we'll talk about what those terms mean. There are some exceptions to the general rule that a contract is enforceable, and these include 1, where there's an unequal relationship between the parties, 2, where one party has misrepresented an important fact, 3, where an important mistake has been made, or 4, where there is a defect within the contract itself. First and foremost, contract law is about consent to the bargain. If there's a defect in the parties' relationship or in the contract itself, or there has been a misrepresentation or an important mistake, then contract law must act. It must provide a remedy when a contract fails to reflect the real bargain or it's fundamentally unjust, and we'll look at examples of all of those. If the aggrieved party, and I mean the person who feels they have been wronged, can bring itself within one of the doctrines I just mentioned, then there are 2 possible outcomes: voidable contracts and void contracts. And you should know the difference between the 2. So a voidable contract is one that in certain circumstances the aggrieved party can choose to keep or bring to an end. So voidable means the aggrieved party can keep it in force or bring it to an end. They have the choice. A void contract, on the other hand, is a contract that has a defect so substantial that it's of no force or effect. For example, a contract to do something illegal has a significant defect, and the contract would automatically be void. So a voidable contract gives the aggrieved party the option to keep the contract in force or have it brought to an end. A void contract, on the other hand, is a contract that has a defect so substantial that it is of no force or effect and is therefore void. So here's a bit of a recap. The law may set aside a contract when there's an unequal relationship between the parties, where one party has misrepresented an important fact, where an important mistake has been made, or where there's a defect within the contract itself. And we're going to look at these in more detail. In general, the law assumes that individuals and organizations have the legal capacity to form contracts. However, children and those with mental incapacities are given special legal protection. Minors fall into this category. So a minor is someone who's not yet reached the age of majority. And the age of majority is that age at which a person becomes an adult for legal purposes. It's set provincially, so the age of majority differs from province to province. The general rule with minors is that they are not obligated by the contracts they make. There are a few exceptions, so we're going to get to these shortly. But generally speaking, minors have the option to fulfill the contractual commitments and enforce the contract against the other party, or they can bring the contract to an end. So it's voidable. Essentially, a minor child is not obligated to perform their part of a contract if they choose not to do so. As I mentioned, the age of majority varies from province to province. Here are the different provincial ages of majority. So you can see in Alberta, Manitoba, Ontario, PEI, Quebec, and Saskatchewan are at 18 years of age. And in the other provinces, it's 19 years of age. Important for you to know, depending on which province you are doing business in. So as I mentioned, there are some exceptions. So to protect minors from the enforcement of contracts that may not be in their best interest, the general rule is that minors are not obligated by the contracts they make. However, remember that the goal of the law in this area is to protect the underaged minors, and so they have the option to fulfill the commitments and can enforce the contract against the other party should that party be in breach. This is where the exceptions come in. Minors are obligated by contracts for essentials known as necessaries. We're talking about food, shelter, and other things that the minor doesn't have already but requires to sustain themselves. In order for this rule to apply, there's a two-step test. So in order for a contract with a minor to be enforceable under this doctrine, two questions must be asked. Step 1, is the item being acquired necessary to this minor? By this we mean, does the minor need the items for basic survival, food, shelter, etc.? The second question is, does this minor already have an adequate supply of them? So, for example, if the minor child is living at home in a stable situation with adequate food and shelter, then they already have an adequate supply, so a contract for food or shelter is not necessary and therefore not enforceable. Another exception to the rule that minors are not obligated by the contracts they sign occurs when the contract is a beneficial contract of service. And I quote here, people who are under the age of majority, and in particular those who are over the age of compulsory full-time education, that is, those who are 16 or above, must have the possibility of being able to earn a living. Consequently, the law recognizes that contracts of employment, training, or apprenticeship may be enforceable. So what this is saying is if the contract contains a significant element of training and career development, it's likely enforceable by the courts. Are you sensing a bit of a theme here? Remember that the court wants to protect minors. And so if a contract provides items or services necessary for the minor's survival, or the contract provides for employment or training that the minor might need, thereby allowing them to purchase these necessities, then the contract is enforceable. So then the question is, what happens to a contract that's entered into while still a minor once the minor reaches the age of majority? Well, the rule is this: contracts formed when the person was a minor remain unenforceable against the minor unless the now of age party expressly or adopts or ratifies the agreement. This means that if they enter a contract while they are a minor and they age out, so they become a legal adult, the contract is still unenforceable unless they specifically, once they are of age, adopt or ratify the agreement. Like all things in law, there's an exception to this. If the agreement is of permanent nature or a continuous nature, such as, let's say, a partnership agreement, so an adult goes into business with a 17-year-old under a partnership agreement, in such a case, the minor, upon attaining the age of majority, must reject the obligation. If not, the minor can be held liable from the date the minor comes of age. So if it's an ongoing relationship, like a partnership, then the minor, when they reach the age of majority, must expressly reject the obligation, say, no, I don't want to do that. If they don't, they can be held liable from the date that they came of age. Individuals are also deemed to lack the legal capacity to contract if they're mentally impaired through illness or intoxication, to the extent that they're unable to understand the consequences of their action. When this happens, the person can seek to avoid the contract, but only if the other party had awareness of the mental impairment. This is key. The other party has to be aware of the impairment. It's actually really interesting when these cases get to court, because how do you demonstrate that somebody had an impairment to the extent that they couldn't understand the consequences of their actions? So in terms of intoxication, it could be knowledge of how many drinks somebody had. It could be behavior that they're displaying at the time of the contract. But as you can probably imagine, it's not always easy to demonstrate this. Now we're going to move on to another circumstance that can impact the enforceability of a contract. Generally, contracts formed under something called duress are unenforceable. So duress, as we're going to use it here, is defined as the threat of physical or economic harm that results in a contract. So if you tell somebody you're going to punch them if they don't sign the contract, that would be duress. Where there is evidence of duress, the law assumes that the threatened party didn't freely consent. So if the person were told that they'd be harmed in some way, and it can be physical, it can be emotional, it can be their reputation, or other negative consequences were used to coerce them, then the contract is not enforceable. Duress also includes economic duress. So it's the threat of economic harm that coerces the will of the other party and results in a contract. An example would be when a party threatens to cancel an important contract unless the other side gives financial concessions or makes payments in return. When economic duress is established, the contract is voidable. Do you remember the difference between voidable and void? So a voidable contract is the one that in certain circumstances the aggrieved party can choose to keep it in force or they can bring it to an end. Essentially, the party who was coerced can choose to keep it or to bring it to an end with no legal consequences. Another area where there's a lack of legal capacity is the doctrine of undue influence. This is the unfair manipulation that compromises someone's free will. Undue influence occurs when an individual is able to persuade another's decision due to the relationship between the two parties. An example of this could be a contract between an elderly person and their caregiver. This would be the case if the caregiver used their position to somehow influence the older person. In cases where there is undue influence, the contract is voidable at the option of the victim. Other examples include contracts formed between family members, or contracts between a lawyer and a client, or a doctor and a patient. It's not unusual to trust people we perceive to be an authority or experts such as doctors. A good example of this would be my dad. So several months ago, I visited him, and he told me he had had a tooth pulled the week before. I asked why the tooth needed to be pulled, and he said, well, I don't know. The dentist just said it needed to be pulled. Now, I'm not suggesting that anything untoward happened here at all, but you can see how a situation where undue influence could occur in special relationships, so relationships whereby someone relies on the authority or expertise of someone else. In these cases, the court is entitled to assume that undue influence has been exerted, and it falls to the more powerful party to prove that no undue influence was actually present. So how then can professionals guard against the legal assumption that undue influence exists? In some circumstances, such as the creation of a business contract between family members, it's a really good idea to suggest that each party seek independent legal advice. The lawyer providing that advice can provide something called a certificate of independent legal advice. And their certificate says three things. One, that they explain the proposed transaction to the weaker party. Two, that the weaker party appears to have understood. And three, the weaker party is proceeding with the transaction on a free and informed basis. The case we're going to discuss next is a good example of the potential for undue influence. In this case, Mr. Dogood applied to the Bank of Montreal for a loan for a condo project. Bank of Montreal said that he needed a co-signer. Mr. Dogood approached his wife, who was a real estate agent, and she did end up co-signing the loan. The banker, contrary to bank processes, failed to tell her to seek independent legal advice prior to signing. The loan then went into default when Mr. Dogood declared bankruptcy. As the co-signer, the bank sued Mrs. Dogood. She argued that there was undue influence as she was trying to keep things tranquil during a low point in their marriage. So she wasn't asserting undue influence from the bank. She was asserting undue influence due to the marital relationship. The legal question then is, did Mrs. Dogood co-sign the loan as a result of her husband's undue influence? The resolution was that no undue influence in this case occurred because of her knowledge of real estate. She was a real estate agent. She knew how these things worked. The loan was therefore enforceable against her. The legal rule or lesson resulting from the case is only if a wife could demonstrate that she reposed, quote, trust and confidence, end quote, in her husband concerning financial matters would there be a presumption of undue influence. It's rather an outdated and gendered approach in the law, and unfortunately, we see this more often than we probably should. The law is a bit slow to evolve. In this case, the majority of the judges' approach was to ensure that only the more traditional and extreme kinds of dependence leads to a presumption of undue influence. It's conservative. This has the benefit of ensuring that a smaller number of contracts will be subject to successful challenge and make banks more willing, perhaps, to lend money to married business people who rely on a spouse to co-sign. It has the disadvantage of being perhaps less than realistic for ignoring the power of emotions in a marital relationship. The dissenting judge in this case was that he attached legal significance to a more nuanced form of dependence and to recognize that Mrs. Dogood's sophistication would not necessarily overcome her fear of destroying the relationship between herself and her husband by refusing to co-sign. In this situation, the bank would have had a better position had they recommended that Mrs. Dogood get her own legal advice. In the end, it didn't matter. The loan was enforceable against Mrs. Dogood. The last doctrine under unequal relationships is the doctrine of unconscionable contracts. And this happens when someone takes advantage of the weakness of another. So there's a two-step process to prove this. The first is they have to prove that there was an inequality between the parties. The required inequality can result if someone is unsophisticated, poorly educated, lacks language facility, or has a lower economic standing than the other party. If this is the case, then you move to step 2, and you have to show that there was a bad bargain or proof of exploitation. So it has to be demonstrated that the terms of the contract greatly advantage one party over the other. There has to be proof of significant unfairness. And it falls to the stronger party to show that the contract was fair. So we're going to look at this in a case next. So this is the case of Downer versus Pitcher. If you're using an older version of the textbook, it won't be in your textbook, but I've included most of the key facts, so you should be okay. It is in the newer version. So the key facts here are that Downer rear-ended a cab owned by Pitcher. Rather than go to court, Downer agreed to pay to repair the cab, as well as $300 for loss of income while the cab was being repaired. Downer had Pitcher sign something called a full and final release, basically saying that no further claims could be brought against Downer. Downer had a lawyer, and Pitcher did not. Later, Pitcher discovered that she had soft tissue damage due to the accident and sued Downer. The legal question here is the release a full defense to Pitcher's claim, or should the release be set aside on the basis of unconscionability? The Newfoundland Court of Appeal upheld the release and said there was no unconscionability. Pitcher was considered meek and unsophisticated but the appellant court felt that there was no real inequality of bargaining power and felt that Pitcher was capable of looking out for her own interests. It should also be noted that the court recognized that Pitcher had previous experience in this area as she had been in accidents before. So the legal rule resulting from the case, even if the bargain is impoverished or foolish, so even if it's a bad bargain, or the bargainer is meek and unsophisticated, someone can still be capable of looking after their own interests. This case went on to reconfirm the two-step process for determining whether unconscionability has occurred. Okay, that's it for this lesson. I will see you in lesson 4B. Have a great day.